So, do you know anything about loans to public officials? Not surprisingly, there are state laws here in California regulating loans that are made to public officials. And these legal provisions are contained in California's government code in Title 9, Chapter 7, Article 4.6. Article 4.6 is actually titled Loans to Public Officials. It was added to California's government code in 1997. Beginning with section 87460A of the government code, it says that it applies to an elected officer of a state or local government agency from the date of the elected officer's election to office through the date that the elected officer vacates office. Section 87460 prohibits a state or local officer from receiving a personal loan from any officer, employee, member, or consultant of that state or local government agency in which the elected officer holds office or over which the elected officer's agency has direction and control. In addition, Government Code Section 87460 Subdivision B prohibits a public official who's required to file a Statement of Economic Interest, an SCI or Form 700, or who is exempt from the state civil service system from receiving any personal loan from an officer, employee, member, or consultant of the state or local government agency in which that public official holds office. This prohibition on personal loans does not apply to loans made to a public official whose duties are solely secretarial, clerical, or manual. Government Code Section 87460C, Subdivision C, applies to an elected officer of a state or local government agency from the date of the elected officer's election to office through the date that the elected officer vacates his or her office. And this section of the government code prohibits these elected officers from receiving a personal loan from any person who has a contract with the state or local government agency to which that elected officer has been elected or over which he or she has direction and control. Note that this prohibition doesn't apply to loans made by banks or other financial institutions or to any indebtedness created as part of a retail installment or credit card transaction. Government Code Section 87460 Subdivision D prohibits a public official who's required to file a Statement of Economic Interest, an SCI or Form 700, or who is exempt from the state civil service system from receiving any personal loan from any person who has a contract with the local, state, or government agency to which that elected officer has been elected or which he or she has direction or control. And this prohibition also doesn't apply to loans made by banks or other financial institutions or any indebtedness created by retail installments or credit card transactions. It also doesn't apply to loans made to a public official whose duties are solely secretarial, clerical, or manual. There's also Government Code Section 87460 Subdivision E that excludes from these prohibitions loans made to the campaign committee of an elected officer or a candidate for elected office, as well as loans made by a public official's spouse, child, parent, grandparent, grandchild, brother, sister, parent-in-law, brother-in-law, sister-in-law, nephew, niece, aunt, uncle, or first cousin, or the spouse of any of these named persons, provided that the person making the loan is not acting as an agent or intermediary for any person who is not otherwise exempt. And the third is that for loans from a person which in the aggregate doesn't exceed $250 at any given time. Then we have Government Code Section 87461 that prohibits an elected officer of a state or local government agency from receiving a personal loan of $500 or more, except when the loan is in writing and clearly states the terms of that loan, including the parties of the loan agreement, the date of the loan, the amount of the loan, the term of the loan, the date or dates when payments are due on the loan, the amount of those payments, and the rate of interest that's to be paid on the loan. And this section does not apply to certain specified types of loans that you have to check. And then finally, there's section 87-462 of the government code that provides that a personal loan becomes a gift to the debtor in certain specified circumstances. For example, if the loan has a defined date or dates for repayment and the statute of limitations for filing an action for default has expired, it's then deemed a gift. If the loan has no defined date or dates for repayment, when 1 year has elapsed, it will become a gift. However, section 87-462 doesn't apply to 5 specified types of loans, including loans made to a campaign committee, a loan that would otherwise not be a gift, a loan that would be a gift, but on which the creditor has taken reasonable action to collect the balance due, a loan that would otherwise be a gift, but the creditor, based upon reasonable business considerations, has not undertaken a collection action. And the 5th is a loan made to a debtor who's filed for bankruptcy, and that loan is ultimately discharged in bankruptcy.